Hi, I'm Paul Weathers here today with estate planning attorney Aaron Miller, and we were just having a conversation about common questions people have when they go to prepare their estate planning documents. Aaron, thanks again for being here today.
Yeah, you bet, Paul. Appreciate you having me today.
What's the difference between probate assets and non-probate assets?
Well, probate assets are assets that go through the probate process. So those are things like maybe if you own stocks or bonds in your own name or have a bank account in your own name, things like that. Or even houses. Houses are usually probate assets even if it's your name and your spouse's name. That still has to go through some form of probate. A non-probate asset would be things that are beneficiary designated typically. So insurance policies, an annuity, things like that are non-probate assets. Basically things that go to your heirs and your beneficiaries immediately without having to go through the probate process.
Okay, good. And last year, the Texas transferable death deed became available in our state. Can you explain how that works?
Sure. It's a really neat idea. September 1st, 2015, we had a new law go into effect called the Texas Transfer on Death Deed. And we joined, I can't remember if it was 11 or 15 other states, but it's a pretty new concept. But basically, using this deed, when you pass away, it'll go to whoever you list as your beneficiaries. It's still a pretty new concept. There's some bugs that we think that need to get worked out, so there's not a lot of attorneys that are actually recommending that we use it now for various reasons that could cause some complications with title companies down the road. But it's a neat concept, and I'd like to see some of the bugs get worked out before a lot of clients start using it.
Can you talk a little bit about some of the healthcare documents that you prepare for clients and why you recommend those?
Absolutely. There are 4 documents I think everybody needs to have in place. The first is a medical power of attorney. That's a document that says who can make your medical decisions if you can't. I just want to also caution people that it still allows you to make your own medical decision. This just says if you can't make your decision, who you want it to be. HIPAA is a new law that says your medical information is private unless you say otherwise. I say new law. It's been around since about 2006. We put everybody on the medical power of attorney, also on the HIPAA release, because we don't want to put someone in the position of having the authority to make the decisions, but without having the ability to get the information they need to make those decisions. The next is a declaration of guardian. That's a document a lot of people are surprised about. They think their kids are older and they don't need it, but this is really putting in place who you want to be in charge of either you, that's the guardian of your person, or your estate, that's guardian of your estate and in charge of your finances. This doesn't make him your guardian now, but it says at some point in the future, if you needed guardian, this is who you would want it to be. Also, if you've got somebody in your family, maybe that you give them a nickel and they spend a dime, they may not be a great person as guardian of your estate. We can exclude people. Or maybe they make great financial decisions but not medical decisions. We can exclude them from guardian of your person as well. The other thing is, the last document is a living will. Everybody knows it as a living will, but in Texas we call it a directive to physicians. And what that is just a document that says, listen, if I'm on life support and that's the only thing keeping me alive, and you can't communicate with me at that time, meaning I can't blink eyes, squeeze fingers, talk, whatever, respond in any way, then it says whether or not I want to stay on life support or not.
Okay. Sometimes an investor will want to set up a joint account with their adult child. Mm-hmm. And they'll do this for convenience and to allow that adult child to transact business on their behalf. But what are some potential issues with doing it that way?
Yeah, there's a couple potential problems. First is if you put that person on your account as a joint tenant right of survivorship, when you pass, that person gets the money. Now, that may be what you want, but it could cause problems if that's one of several siblings, because they have the money and they don't have any responsibility or requirement, really, to share that money. Or if they get into any creditor issues, that could be a potential problem as well, because then you have to go and try to argue that the money that's in that account is not really their money, it's your money, and that just causes a problem. So what I usually recommend is either making them a signatory on the account or having a power of attorney in place, and that way they can go and they can deal with the assets in that account.
Okay. Thanks so much.
You betcha.
If I can be doing anything for you, please let me know. Thanks for watching.